Both sides ready?
Yes, Your Honor.
All right, you may proceed.
Good morning. May it please the court. My name is Erin Berger. I represent Martha Arana, the appellant in this matter. I'd like to reserve 5 minutes of my time for rebuttal, please.
All right, you got it.
Your Honor, Ms. Arana appeals to this court the entry of final judgment by the trial court in the underlying property insurance claim dispute following a jury verdict in favor of the Appellee People's Trust Insurance Company and the denial of her motion for new trial. Ms. Arana contends that the trial court erred during the trial in allowing People's Trust to admit the deposition of a non-party factual witness. The witness's testimony was used to contradict Ms. Arana's testimony and contributed to the unfavorable verdict dispensing with her claim. Ms. Arana requests that the court reverse the final judgment and remand the matter for new trial. The underlying issues began for Ms. Arana in January of 2016 following the installation of new flooring in her home by Lowe's Improvement Stores. She began noticing damage to the flooring in her bedrooms. It was wood floor that was had replaced previously installed.
Counsel, the whole issue on the appeal is the reading of the deposition, is that right?
Yes, Your Honor.
If I could ask you right out of the gate, as I understand it, the deposition was noticed for the Friday before the Monday trial, is that right?
Yes, Your Honor.
And the deposition notice did say on there it was going to be used it was for use at trial, among other things, right?
Among other things, Your Honor, but the issue is that prior to the scheduling of the deposition, there was a motion filed to extend the discovery deadline.
I know, but towards the end, right before the deposition was taken, there were 3 different notices that went out that this witness was going to be subpoenaed and that the testimony may be used at the trial.
I think that the characterization...
I guess I'm having a hard time understanding the complaint that there was a surprise or that the trial, that this was not taken for use at trial when the notice said that it would be.
Well, I think that that statement in the notice of deposition is just generic legalese that's included in most notices of deposition. I don't think that appellee ever really notified Ms. Arana or the court that it intended to take the deposition testimony of Mr. Flores for the purposes of preserving the testimony for trial. In the motion that was filed to extend the discovery deadline, it was simply to extend the discovery deadline because they had not been able to meet the discovery deadline for taking the deposition of their factual witnesses. The language that was used in the notice of deposition also said for the purposes of discovery, use at trial, or any...
I know, but I think you have to, looking at the timing as well, since the deposition was taken Friday and the trial was Monday, I mean, it wasn't really, there wasn't a whole lot of discovery that was going to lead to at that point. It just seems to me that if I was the attorney in the case, I'd be thinking there's a very good chance that they're going to want to read some of this at the deposition since this is a witness that's under subpoena and trial starts Monday.
Perhaps, Your Honor, but use at trial could also mean just for the use of impeachment purposes. I don't think
it could, but it doesn't say that.
No, but it also doesn't say for the purposes of preserving testimony in lieu of live testimony.
For use at trial, is that broad enough to encompass the reading of part of the deposition? It seems like it's a pretty broad statement. I understand what you're saying. I mean, I practiced for 19 years myself, so I'm not, a spring chicken on these issues. And I know that it isn't as clearly marked as some might be, but it just seems like the circumstances are such that if I was on the other side, I'd be thinking, I better watch out because there's a very good chance they're going to want to use this at trial, especially because the notice says that they will.
Perhaps, Your Honor, but again, there's a flurry of activity.
In other words, that gets to the question of motive and opportunity to cross-examine, which is the basis for the admission.
Right, and again, that goes back to the fact that, Ms. Arana's trial counsel agreed to the extension of the discovery deadline for purposes of completing discovery, not for the purposes of preserving any testimony or witnesses that would not be able to appear. There was never any indication to Ms. Arana or her trial counsel that Mr. Flores would not be able to appear at the trial. There was never any indication during his deposition testimony that he did not intend to appear at the trial or that People's Trust would not be calling him to appear at trial. The only indication that Ms. Arana ever received, I'm sorry, Judge, I see your mouth moving, but I can't hear you.
No, I'm not saying anything.
Judge Smith, I'm sorry.
Oh, Judge Smith's mouth is moving. Judge Smith, you're not, you are unmuted, but I can't hear you.
It's gone out again. Okay.
There you are.
Now?
Yes.
Oh, okay. And forgive me, my volume has been going out on my monitor here, but okay. So my question is this. This deposition of Mr. Flores was the first time that he was deposed in this case. Is that right?
Yes, Your Honor.
Okay, so it's not like it was a second deposition or a follow-up or continuation. This is the first time he's actually deposed, but he was disclosed on the pretrial witness list. Is that right?
Yes, Your Honor. He was timely disclosed by People's Trust as one of their intended trial witnesses.
Okay.
There was never any hiding of this witness. They knew about him and they knew that he existed. And that's what makes this a little bit more troublesome, I believe, is because it just appears that they waited and waited until they ran out of time and they didn't diligently seek discovery.
And on the actual notices of taking deposition, I believe there's like 3.
Yes,
is that right? Okay. And they start off with like all deposition notices. I think it says pursuant to rule 1.330, right? Yes. Is there anything on those notices that actually cite to the former testimony 9803 that People's First is relying on here?
No, Your Honor. Again, no indication whatsoever until the day of trial that they intended to rely on that statute or intended to read the deposition in lieu of Mr. Flores's live testimony. And the reason this is problematic is because, as this court stated in Friedman versus Friedman, you know, there's a difference that counsels go into trial depositions and versus discovery depositions. In a discovery deposition,
what then was the harm here, though, with the entire deposition being read then?
The harm is that, Your Honor, there was no other testimony presented by People's Trust that contradicted anything that Ms. Arana said about the factual situation. There was 5.
That leads me to my next question then. I noted in the transcript, there's no rebuttal, though, by Ms. Arana. I mean, she could have offered some rebuttal testimony that would have countered the Flores deposition, but for whatever reason, counsel chose not to put her on and provide any rebuttal testimony.
That's correct, Your Honor. There was no rebuttal, and I can't speak to trial counsel's reasoning for that. But again, it highlights that there's no other testimony that was presented that contradicts her testimony, in that, you know, People's Trust presented 3 other witnesses. One was simply a damages expert who provided a damages estimate that her property needed about $15,000 worth of repairs. He was not qualified to and was not asked to offer any testimony or opinion about the causation or the duration of the water leak. The other expert that they presented testified that his scope of inspection was limited to the bedroom. So he didn't ever even look at the kitchen or the other areas where
what is the damaging aspect of Mr. Flores's testimony that is being claimed? Is that he contradicted the plaintiff, correct? He contradicted
yes,
her on the timing of the leak?
There's a couple of things, Your Honor. Her testimony was that, you know, she'd recently had this flooring installed by Lowe's, and before she contacted People's Trust, she didn't really know what was going on. She claimed she didn't know where.
She apparently had some water intrusion in January when she replaced the flooring.
Her testimony was that she noticed the weird sound. She felt like there was air under the flooring. So she called Lowe's to try to have them remediate any issues that there were with the flooring installation. It took them some time to come.
They found there was some water. They did find some water problems, correct?
They did, and it was.
I mean, isn't that the real gist of this? Is that she was on notice of water intrusion in January, but made no claim until April?
Well, that's what People's Trust is claiming, Your Honor. But the reality, or her testimony was that she noticed this in late January. Lowe's came in February and March to try to figure out if there was something to do with the flooring. They offered to help her with drying out the floor. And then when they realized, or they told her that there was nothing they could do because it had something to do with water intrusion, then she made the claim to People's Trust. People's Trust denied the claim, saying that there was an issue with water or the flooring installation, and that she had not given them timely notice. But that's sort of the issue, and the harm that's caused by Mr. Flores' testimony is that, you know, he testified that when he was contacted by Ms. Arana, that she knew what was going on. She knew where the leaks were and that type of thing, but she testified that she didn't know. And that's what the issue in the delay was, is that nobody could really tell her what was going on. The inspectors sent by People's Trust said that they couldn't find any leaks, or that it was this issue. The expert that Ms. Arana presented said that he did not believe that it was an issue that People's Trust identified, and that there was water soaking up through the foundation because there was a layer of visqueen between the flooring and the foundation. So there was a lot of conflicting testimony, and without Mr. Flores' testimony to contradict hers in terms of their relationship and what happened when she contacted him, and you know, what she knew and what she didn't know, there was no reason for the jury to disbelieve anything that she said. And that's why there's a harm in this deposition being read in, because again, her trial counsel didn't go into the deposition the Friday before trial thinking that he wouldn't be appearing at trial for him to cross-examine at that time. He went in thinking they're just trying to complete discovery to get an idea of what he's going to say at trial. And this happens all the time in these cases. And so the fact that they showed up on Monday, filed a designation of the deposition, you know, after the trial had begun that day, you know, was a surprise to their trial counsel. They made a contemporaneous objection. I know in the answer brief, People's Trust mentions that they did not believe that Ms. Arana properly preserved this argument. But again, this wasn't an issue like the cases cited in the answer brief, where there was a motion in limine made before the hearing or before the trial. Again, this is not something they were aware was happening even before the trial. But they did make a contemporaneous objection when it became clear that People's Trust intended to rely on this deposition. And again, the issue was raised in the motion for a new trial, which distinguishes this case from the cases cited by People's Trust in their answer brief. In those cases, it was either where there was no contemporaneous objection whatsoever, other than a motion in limine prior to the start of the trial, or there was no motion for new trial after the trial, or just no objection whatsoever. Again, the harmful error in the admission of the deposition is that there was no other testimony that contradicted Ms. Arana's testimony concerning the events that transpired and her version of it. This court in Friedman versus Friedman did state that there is a difference between what a trial counsel will do in preparation for and at a deposition taken for the purposes of discovery. And I think that's evident in this case. And in that case, this court unequivocally said that Rule 1.330A3 still applies in this very situation, that there has to be some demonstration that the witness is unavailable, or there's some extraordinary circumstance that would allow the reading in of a deposition that's not of a party, or let me find the quote exactly. I don't want to misstate it. Discovery depositions should not be allowed to be substantive evidence at trial. The attorney taking a discovery deposition does not approach the examination of a witness with the same motive as one taking a deposition for purposes of presenting testimony at trial. Again, Your Honor, the record here does demonstrate that, you know, there was not sufficient notice or any notice whatsoever that Mr. Flores' testimony would not be live at the trial. It's possible, or it's probable, that trial counsel would have approached the deposition on the Friday before the trial in a different manner in order to preserve their side, and to maybe present Mr. Flores with more questions concerning his contradictory statements. Also, the deposition that was attached to my appendix shows that the full deposition was not read into the trial transcript. People's Trust Trial Counsel did not include the limited number of questions that counsel for Ms. Arana did ask. And for that reason, it's somewhat prejudicial, suggests to the jury that there was no questions asked whatsoever, even though there was only one or two, but that perhaps Ms. Arana did not take issue with any of the deposition testimony. Again, this presents a problem in harmful error in that the jury would be led to believe that, Ms. Arana should not be believed and has no issue with the deposition testimony of Mr. Flores. For that reason, because the trial court erred in allowing the admission of the deposition testimony under 90.80322, and it resulted in harmful error for Ms. Arana, we would request that the final judgment be reversed and the matter remanded for a new trial. And I'll reserve the remainder of my time, Your Honors.
Good timing. You're right at 5 minutes.
Great.
Counsel, you may proceed.
May it please the court, Michael Rosenberg on behalf of People's Trust. The trial court's denial of the motion for new trial and final judgment pursuant to a jury's verdict must be affirmed because Ms. Arana's evidentiary arguments were not preserved for appeal, or in the alternative, if preserved, the trial court did not abuse its discretion when it permitted the deposition of Mr. Flores to be read to the jury pursuant to the former testimony hearsay exception found in section 90.803, subsection 22. Judge Smith, to address your question that you asked earlier in the proceeding, whether or not the notice of deposition contained a disclaimer that the testimony was going to be used under the former testimony hearsay exception, I'm not aware of a requirement under the Florida Rules of Civil Procedure that requires such a.
And I'm not, can you hear me?
A little.
A little, can you hear? Okay. I'm not saying that the rules require it. I guess I'm pointing out that with respect to the, the cases that talk about the, you have this same motive and opportunity to cross-examine a witness. My concern is that your argument is a bit disingenuous that we should not follow the rule 1.330, but we should follow here 980322 in the former testimony. But your very notice when you're noticing the deposition cites the rule. And so it's a bit inconsistent with your argument is all I'm pointing out.
Understood. So this then goes back to Judge Black's statement, which I wanted to bring up, is you have to consider the circumstances under which this testimony was taken on the eve of trial. The way that the deposition came about, where it was taken on the eve of trial, was pursuant to a motion to extend those deadlines. And this is in the record on page 351 in paragraph 2, where the defendant states that defendant continues to endeavor to complete discovery, including depositions, necessary fact and expert witnesses for trial. So specifically in the motion itself, it states that the depositions that needed to be taken were being taken for trial. So that's in the record on page 351.
But Mr. Rosenberg, Mike, can you hear me?
Yes, Your Honor.
Okay, so, but for use at trial could mean for impeachment purposes, right? I mean that's kind of broad. And so I guess the concern here is the gotcha. Okay, I'm going to sit quiet. I'm going to let you disclose the witness on a pretrial stipulation that says this witness is going to appear live, but I'm going to wait until the morning of trial and then give you my deposition designations when there's been no conversation whatsoever, either in the motion or, hey, if it was for use at trial and you were intending to have that witness simply use the deposition, then why wasn't it fully developed about that witness's availability? That it would have complied with the rule. So what you're saying is you don't have to comply with the rule. We're just going to use 9803 anytime we decide that a witness shouldn't appear live. Maybe at the last minute they decided strategically that the witness wasn't going to be a good witness on the stand for the jury.
So Your Honor's question goes a little bit beyond the scope of what was briefed in the appellant's argument, although I'm prepared to address it, which touches on the constitutionality of 980322 as applied to civil cases. When you look at Rule 1.330, the use of depositions at trial, A1 says that any deposition may be used by any party for any purpose permitted by the Florida Evidence Code. So under 1.330A1, if a deposition can be used, it's permitted by the Evidence Code. So then we jump over to 9803, which states at the very beginning of the statute, the following, the provision of section 9802 to the contrary notwithstanding, the following are not inadmissible as evidence, even though the declarant is available as a witness. So the Florida legislature put an exception, the former testimony hearsay exception under 980322, which allows testimony to be published to a jury as substantive evidence, regardless of the availability of the jury. And so when you read Rule 1.330 in conjunction with 980322, it's clear that subsection 3 of the Rule of Florida of Civil Procedure, specifically the witness's availability, is not at issue. The statute writes that rule of procedure out. And so we've had those, Florida courts have debated the use of 9803 subsection 22 in both criminal proceedings and in administrative proceedings. And courts in those cases have determined that the use of a trial deposition is unconstitutional. Whereas in a civil proceeding, those heightened concerns of lack of cross-examination are not present. And that's what this circuit decided in the Friedman case that my opposing counsel raised, where this court in 2000 noticed the distinction between a discovery deposition and a trial deposition. And that's where Judge Black's questions are extremely important, because if this was a discovery deposition, for example, taken months before trial, I would understand the court's concern that there's a trial by ambush, because at that point in time, during the normal course of discovery, there isn't the same motive and opportunity for a opposing counsel to develop those questions. In our case, you have a motion that was seeking leave for a deposition to be taken for use at trial, as stated in the motion, and then the order.
Mr. Rosenberg, can you hear me?
Yes, Your Honor.
Okay. So if that was the case, that the whole point was to have that testimony used for purposes of trial, then why was the disclosures, the pretrial disclosures on witnesses, why was that not amended at the same time?
I don't know the answer to that question, Your Honor. We don't have the benefit of that information in the record. We do know that the witness was listed as a fact witness. Okay, so there's. You're conceding that it was not amended prior to the disclosure on the morning of trial. I don't. It's not that it's a concession. I don't think that there's a requirement under any rule of procedure that would require such an amendment, because the testimony being admitted is being admitted pursuant to the former testimony hearsay exception. It's not hearsay, it's admissible evidence. And so the question that the court needs to decide is whether there was the same motive and opportunity for opposing counsel to develop the testimony. And again, it's really important, because this is all the only information that we have before us is the record evidence. And what I was going to try and put in is at page 362 of the record, when the court enters its order granting the motion for this discovery deposition to be taken for purposes of trial, as expressed at paragraph 2 of the motion, the parties agreed to it. So to say that they were unaware that the testimony could have been used at trial is something that can be used in hindsight after the jury's verdict. And when you look at the arguments that are actually made to the trial court, and this is in the record at page 386, the issue was the availability of the witness. The issue, the objection that was raised at that time was not whether or not there was an opportunity, but whether or not the plaintiff's counsel had the motive and opportunity to develop the testimony. The issue that was argued before the trial court was the availability of the witness. And as I've explained, 9803 subsection 22 doesn't require the availability, which sort of dovetails into my argument about the preservation of the appellant's argument. There's no question that the appellant had objected to the use of the former testimony. That was discussed just after the jury was sworn in, and the parties went back and forth on their arguments before lunch. The trial court requested the information case law to support both sides' positions. When the trial court came back from lunch, and this is in the record at page 392, the court states as follows: just so you know, I've looked at the rules. I'm going to allow the reading of the entire depo in. And this goes back to plaintiff's counsel's statement that if the transcript was going to be read, to read the whole transcript into the record. Continuing, I'm going to ask that you figure out during the break who is going to read and who is going to ask the questions. Then if you want during your time, you can switch off, or it might be easy just to use the same people. Plaintiff counsel responds, that's fine. There's no objection at that point in time. There was a ruling at that point in time, and the court says we'll take a 10-minute break, and that's in the record at page 392. With respect to the appellant's contention that the very limited cross-examination was not read to the jury, on page 418 of the record, after the deposition concludes, People's Trust Counsel states that's the extent of it. The court says that's the end of it. Ms. Perez says, yes, Your Honor. The court, do you have any question? Ms. Perez, no, Your Honor. So again, Judge Smith, that goes back to your point that if rebuttal evidence wanted to have been brought in at that point of the trial, again, an objection could have been raised, rebuttal evidence could have been brought in, but it wasn't. And so the court says, so that's the end of this deposition. Yes. Okay, you can step down. Thank you. So we don't know what the parties discussed outside of the transcript of who was going to read what, whether the whole party was, whether defense counsel was supposed to read the cross-examination. Whatever may have happened, any error with respect to appellant's contention is cured because they said, no, we're not going to read anymore. And so I think that this court can ignore that part of the argument.
Counsel, could you address a little bit the harmless error aspect of this? As my understanding is that the complaint by opposing counsel is that there was something said by the witness that didn't come from any other source about contradicting the plaintiff's version. It was my understanding that there was expert testimony and other testimony that laid out people's version of the way they interpreted this apart from Mr. Flores's testimony. And so it was nothing shocking or dissimilar about what he had to say, but I'd like you to clarify that and elaborate on that.
Absolutely, Your Honor. So as we pointed out in our answer brief, the reading of the deposition took 20 minutes. The trial lasted 2 days. So the actual testimony itself was a very small portion of the presentation of defendant's case in chief. The jury was charged with one simple question that, if answered yes, led to more questions. Did plaintiff Martha Arana prove by the greater weight of the evidence that her property sustained a sudden accidental loss from a plumbing system on or about January 28, 2016? The jury answered that question, no. So the testimony and evidence that this court needs to consider as to whether there was well, I guess, first we're dealing with the abuse of discretion standard as to the admission of the evidence. As to the harmless error, the plaintiff's expert testified that the plumbing leak started as a small spray and could have been a few days old. whether the jury chose to agree with that contention or not, we're starting off with the fact that there's a slow leak. There's not a sudden and accidental discharge. You have pictures that were submitted to the jury that showed mold. Well, mold develops over the course of time and isn't necessarily indicative of a sudden or accidental discharge. The contradictory evidence with respect to Mr. Silva's deposition testimony itself is actually inures in favor of the plaintiff, because you have the plaintiff's expert who is testifying as to this small spray, whereas you have Mr. Silva saying water was visibly coming out of the wall. Well, Mr. Silva's version of the story that occurred would actually help plaintiff out, because that at least might put the question in the jury's mind that it was a sudden or accidental discharge. The other testimony that you have where it contradicts is where the leak was. And so where the leak was really isn't the core issue of this case. It's, was there a sudden and accidental discharge? And so you have Ms. Arana's testimony saying she doesn't know where the leak is, she doesn't know where the leak is. But then you have Mr. Silva who says, no, I showed up and Ms. Arana showed me exactly where the leak was. That really isn't material to the issue before the jury.
It was the location of the leak that it was being claimed that was the damaging contradiction, as I recall.
Well, what Mr. Silva had stated was that the leak came from the kitchen, which would
contradict what she said.
Well, she didn't know where, she claimed she didn't know where it came from. That was her testimony. She didn't know.
The issue isn't location as much as the nature and the suddenness of the leak.
And that, Your Honor, is exactly the point, is that the jury was charged with the question, was this a sudden or an accidental discharge? And the jury answered that question as no, because there was no testimony that showed that there was, a break where water's pouring out of the wall. Rather, the evidence in the record shows that this was a slow leak that occurred over time. And when you read closing arguments for defense counsel, you'll see the defense counsel point that out, and how a slow leak is an exclusion under this policy. And so taking all of the evidence together, the jury had enough evidence in the record to come up with the answer no. Again, whether or not there was evidence to support the jury's determination is not framed by this appeal. The question is strictly whether or not the trial court abused its discretion in allowing this, what I will call a trial deposition, into the record. Because again, you have to look at the motions that led to this trial deposition being taken. You have to look at the notices, and everything says trial, 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 trial. And I don't think, this is supposition, it's not in the record, but I would hope that an attorney on the Friday before the Monday that trial starts would at least have a question in their mind as to why depositions being taken at that point in time, and attempt to develop the record. I think I'm running out of time, so unless your honors have any more questions, I'll yield the rest of my time and rely on our briefs.
All right, sir, thank you.
Thank you.
Ms. Berger, rebuttal? Just
briefly, Your Honors. With regard to the motion that was filed to extend the time for discovery, the paragraph actually states that they're requesting extension of time to complete witness discovery in furtherance of preparing for trial, not for trial or not for use in trial, but for preparing for trial. And again, that was on September the 19th, almost a month out from the trial. So again, there's no indication or reason for Ms. Arana's trial counsel to think that if they're agreeing to an order to be entered on that motion, that they're agreeing to depositions to preserve trial testimony for trial. The record with regard to a trial counsel's objection is slightly more involved than appellee's counsel has stated. although in the end, they did agree to the reading in of the entire deposition, that was to cure any prejudice that might come from reading in portions of it. But trial counsel unequivocally stated at page 175 to 176 of the transcript, I want to place my position on record. We're not agreeing to it. But she said, if you're going to allow it, it needs to be done in this manner. So she did preserve her objection to the reading into the transcript itself. The objection that was made at trial regarding the availability and failure to comply with Rule 1.330A3 just gives further insight into how trial counsel approached this. They didn't know that this deposition would be read because they assumed that he would be there. They were proceeding under the impression that he would be there that day for them to examine at trial. That's the objection that was made, and lends further insight into the surprise that they had when they were told that day that Mr. Flores' deposition transcript would be used in lieu of live testimony. The location of the leak, as discussed, was not necessarily the issue. However, the issue was that Mr. Flores, again, was the only witness that would contradict Ms. Arena's version of the events. The People's Trust witnesses, their expert witnesses, testified that there wasn't a leak at all and that it was a foundation.
But the point of Mr. Flores' deposition and vis-a-vis the plaintiff's deposition on location doesn't matter.
Right. What matters is that.
So why isn't it harmless?
It's not harmless because there was no other testimony offered concerning what her version of the events was, that there was a sudden an accidental discharge. Again, she went from having carpet before to having wood floors. She said that there was never an issue in the same rooms with there being water in the carpet. So, her testimony contradicts, the experts that People's Trust presented that said, well, it was a foundational issue. There's water coming up your foundation. She never had those issues before. These issues only appeared in January of 2016. And she testified that after Mr. Flores made, the repairs, there was never any issue again. The expert she presented, Mr. Rivera, also testified that there was no evidence when he inspected the property that there was any continuing issues. So, the location of the leak is not necessarily the issue, but whether it was sudden or accidental is the issue. And her testimony suggests—
And the two of them did not disagree on that issue.
They did not, but they disagreed about her version of the events and what transpired, what she knew.
But on the salient point, the most important point, they were in harmony.
In terms of where the leak was, yes.
Yes.
But, his deposition testimony about, whether they knew each other beforehand, what she knew when he did show up, what he did, those things were in contradiction. And that lended to the jury's disbelief potentially of her testimony as People's Trust.
And just to be clear too, that witness had been disclosed on July the 12th for an October trial. So it wasn't like the witness was sprung at the last minute or there was some surprise. That witness was available to be deposed by the plaintiff for several months prior to trial.
Yes, and again, Your Honor, that, again, as Pelley's counsel said, supposition, but, our position is that they just didn't do it in time. We're racing to get it done. And at the last minute decided it would be a deposition they would use.
But, if the plaintiff was concerned about his testimony, the plaintiff could have deposed him.
Correct.
All right.
Your Honor, again, we would request that the final judgment be reversed based on the error of the trial court admitting the deposition into evidence and the harmful error that was created by it. And we'll rely on our briefs for the remainder of our argument. Thank you.
You have impeccable timing. You're right at 5 minutes again. Thank you very much. Well done.
Thank you, Your Honors.